Hello, my name is Joseph Jones, and today we're going to be talking about some of the Bill of Rights. First, we're going to be talking about the 4th, 5th, 6th, 7th, and 8th Amendment. Looking at these amendments, we're going to be looking at the rights of the accused, some specific cases that deal with each amendment, and the limits and scope of each amendment. First of all, the 4th Amendment covers search and seizures. This is what gives the cops the right whether they need a warrant or not. What gives them probable cause, and how to obtain a warrant. Moving on. In Katz versus United States, Charles Katz was a well-known gambling bookie, and he would use the public telephone to send calls all over the country, but mostly from LA to Miami and LA to Boston. Well, the FBI caught on to him, and they started bugging telephone booths in his neighborhood. And finally, they got a conviction off one of his phone booths. They caught him on tape, but was later overturned because the Supreme Court ruled the FBI violated his right to privacy. There are exceptions that a cop uses to not obtain a warrant, but he can still search. Most notably, the consent. This is the most common. This is when the person he is asking to search whatever he needs to, they say, yes, you can do this. However, this cannot be coerced, which means he cannot say, you better let me search your bag right now or I'm going to take you to jail. That is coerced. Next is in plain view. If the cop can see it, he can search anything that is around you. Open field. Open field basically covers woodlands, pastures, open water. It's basically covered. If he wants to, he can search it without a warrant. Next is curtilage. Curtilage is if you have a house, if they have a warrant to search your house, but then you have a barn out back, even if it doesn't say on the warrant that they can search your barn, it is covered under the curtilage clause. Next, motor vehicles. And at borders. This is kind of tricky, but at borders, because so many people traffic guns, drugs, and other contraband across the borders, they're allowed to search motor vehicles at any border randomly, whether you look at them the wrong way, every fourth car, because it's so likely that something's going to be in it that's not supposed to be. And extingent. Extingent arises when an officer believes that his life or the people around him's life's in danger, and he can search it. He can search any room, whatever he wants to, as long as he's not motivated by looking for an arrest and the information he can find. He's not looking to collect evidence of arrest. And what most people don't know is K through 12 schools, cops do not need a search warrant to search lockers and cars and the parking lot stuff. This is why they use the drug dogs, because they use it so it keeps everyone safe, and it's just beneficial if the cops they can search when they need to inside schools. Next, moving on to the 5th Amendment. The 5th Amendment deals with due process. And due process is a legal requirement that the state must respect all the legal rights that a person is owed. It also covers self-incrimination, which means a person can refuse to answer questions if they want to. It's called pleading the fifth, because if they answer them, it can provide evidence of crimes that they've committed or their involvement, which they can use against them. Double jeopardy is under cover. This is a very common, but what this states is that no person can be tried for the same crime twice, which is actually a pretty good movie out there about it, and I recommend seeing it sometime. And next, finally, is grand juries. Grand jury is a type of jury that determines whether a criminal is convicted or innocent. So if you ever see on TV and they're in a courtroom and they say guilty or innocent, that's a grand jury. The most notably important 5th Amendment case is Miranda versus Arizona, which was Ernesto Miranda was arrested based on evidence linking him to a kidnapping and a rape of an 18-year-old girl. He was taken to the police station and gave a complete confession. Well, after he was like, you know what, you guys never told me the right to remain silent, or they never told him that he had the right to a counsel or any of this, so he tried to appeal. However, the Arizona court said, you never specifically asked for an attorney, so you are still convicted and not overturn his appeal. However, from this case, they call it the Miranda rights, and this is when you're arrested, a cop must read your rights, why you're being arrested, and the fact that you have the right to remain silent, and you can have an attorney provided for you if you cannot afford one, which is very important. And the Sixth Amendment. The Sixth Amendment covers the right to a fair and speedy public trial. We're going to talk about it in a second, but moving on to the accused rights. The accused rights of the Sixth Amendment are they can retain counsel. If you cannot afford it, then one can be provided to you through the state that you need an attorney. And obtain witnesses. If you need a witness and he cannot be found, or you find him and he says, no, I don't want to go in, the court can make him testify in your favor if it makes you in favor for you. And we're gonna talk about the fair and speedy public trial. There's four criteria that goes with the fair and speedy public trial, and it comes from the Barker v. Wingo case. The first is the length. The length, you must have your trial by the time, the 1 year after your arrest. If you do not, then you can say that you violated my Sixth Amendment and you can get off scot-free. But, however, there are circumstances of the reason why they held you. The prosecuting attorney cannot hold you for over a year to help build his case. If it's over a year, then that doesn't count. However, but if they're looking for witnesses for you or for them, then he can go under exception. The next is the time and manner. If you agree to the delay of over a year, you cannot later go back on that and say, you guys have kept me over a year, you're violating my Sixth Amendment. And finally, degree of prejudice. This is a general statement, but basically, they cannot hold you for over a year if it's unfair to you, by any means. Next, retaining counsel. In Johnson v. Zerf, Johnson was convicted of, in a federal court of possessing and passing counterfeit money. When he was convicted, he chose to represent himself. After he was convicted, he said, wait, I never got my attorney. But as soon as you say you want to represent yourself, then you no longer get the right to counsel under the Sixth Amendment. And the Seventh Amendment. The Seventh Amendment states jury trial. The right to a jury trial in certain civil cases, but if you go to jury trial in certain civil cases, after the decision is made by the court, they cannot re-examine this by another court. That is very important. And finally, the $20 clause. The $20 clause was put in the Constitution when it was first made. It basically prevents small claims courts and smaller cases from going into federal court. Today, for a diversity case, the amount must exceed $75,000 or will never see a federal court. And the Justices versus Murray. This is a very complicated case. Basically, under the Seventh Amendment, it says you have a right to a jury trial in certain civil cases. Although the Supreme Court do not take these cases, in the Justices versus Murray, they said, well, let's take this particular case where Murray actually ended up getting off due to the fact of it was in the United States court, but they have included this clause into the state courts. Now, the Eighth Amendment. The Eighth Amendment says there will not be excessive fines, which means you cannot be fined for stuff. They have a set amount of things, and they can't jack it up on you. They can't jack up the fine just because of who you are. The next is bail. Bail is very important. When you get arrested and you go to jail and you're waiting for your trial, they can pay money to get you out of jail, so you don't have to sit in jail the entire time waiting for a judge if it's a weekend or things like that. And the Eighth Amendment covers cruel and unusual punishment. This includes, most notably, hangings and whippings, and that's not done now. But more recently is lethal injections that they give people. And in Furman versus Georgia in 1972, they determined there's 4 principles that they use to determine if a punishment is cruel and unusual. First, being the essential precedent. This means, is it severely severely degrading to human dignity? And that covers things like torture and things of that nature. Arbitrary fashion is self-explanatory. That means over the top, brutal. Is it not necessary? This is interesting. Society views. It's how's if it's rejected through society, then it's most likely cruel and unusual punishment. And finally, is it blatantly unnecessary, which means over the top, brutal, arbitrary fashion. And as you can tell, this picture, this is from a slave, most notably a slave who had been whipped in his back several times, where it has produced that brutal amount of scars, which is very wrong. In the United States versus Bahakajian, there's a law that states if you are going to leave the country with $10,000 or more, you have to claim it when you hit the U.S. Customs. Well, Bahakajian did not, and they were going to fine him $357,144. Well, as you can tell, that's an excessive fine. He fought it, went to court, and won, and he ended up being charged anything.